We actually have another question, Lance. Joe is calling a little bit off topic, but he's talking about a default judgment. Joe, what's going on?
Well, I went to court over a security deposit that was paid on a condo that I was renting, and the landlord had refused to return the security deposit, so I took him to court, and the judge issued a default judgment in my favor, but I can't get the guy to collect. I've talked to one guy about possibly putting liens on properties, and just seems like it's a little more trouble than it's worth. I'd really just, wanted to find out what steps I can take legally to collect on the judgment.
The amount of the security deposit, Joe?
It's over $3,000.
Okay. So it's within that small claims, and it sounds like you've already gone through the small claims process to get the default judgment. For those that are watching at home, a default judgment is a situation, we talked about small claims court. You show up, you present your case, you file a lawsuit, you have to serve the other party so that they have notice that a lawsuit has been filed against them, and then the court sets a date for both the parties to come to the courthouse and try to work out some sort of a deal. And there's a mediation process that's built in that where you typically try to do that. But if somebody is served, and it sounds like Joe properly served the landlord in this case to get his deposit back, and the landlord didn't show up, and if the landlord doesn't show up, then the judge is going to enter judgment in Joe's favor. Now Joe's got to go and collect. So, over $3,000, again, you kind of get back to that situation with, hiring a lawyer. There's a lot of work that typically goes into collections, but there are some remedies for Joe, again, probably through the clerk of court. What are some of those things? We hear the words levy and garnishment and things like that. What are Joe's options now that he's got the judgment in hand?
Sure.
How does he get money from this landlord?
Well, and I think the simplest process, at least, is you can assert a lien against any kind of real property that the landlord might have in the county by getting a certified copy of the judgment and recording that in the public records, basically the land records, and that will act as a lien against any properties that he might own. If he tries to sell that, or he does sell it, then your claim would have to be satisfied out of those the proceeds of that sale. Now, that's relatively cheap and something you could frankly do on your own. Once you get into other avenues of collection, writs of garnishment, where you're going out trying to, if you know where his bank account is, you could have a writ of garnishment issued where the bank would have to turn the money over to you, or you can even foreclose the lien. If you create that lien against his property, you could foreclose it and force it to be sold to recover your $3,000. They would have a public sale at the courthouse, and whatever is left over after your claim is paid would go back to the owner. But there is a process there, but it gets a lot more complicated. And at that point, you certainly would need a lawyer to help you out with that sort of collections. But as far as creating that lien that's kind of sitting out there and prevents him from being able to sell any of his property without satisfying your claim, that's a relatively simple thing that just requires you to record a certified copy of the actual final judgment.
Yeah, and I think if you can put a lien on their property,
that gets most people.
That gets most people off, off the. Yeah. Well, I'm trying to think of the right word to say that's TV friendly.
Yeah, especially over $3,000.
Yeah.
I think you'd probably hear from him relatively quickly.
Exactly. All right, Joe. I hope you can get some relief and get your money back.